event. We have a fabulous lineup for you, and we are excited that you are joining us. My name is Robyn. I am part of the Republican Women's Federation of Michigan, resting president as I'm in the process of recovery and excited about the opportunity to be able to be here with you. I'm so used to doing this on conference calls. I would love to say, hey, shout out your name and tell me where you're calling in from, but we probably shouldn't do that. We are going to be recording this, so we will have it available in case you do have to duck out for a little bit, or if you want to review the information. You probably won't be able to take as many notes as you would like to. I know the guests that we have today, and if you tried to keep up with everything with you, your pen would be smoking. So sit back, absorb, jot down just a few things, but relax in the fact that this is going to be recorded, so you will be able to tune in and grab the replay and be able to review the information that comes to you. Thank you so much for joining during Patriot Week for our Rule of Law Tour 2020. We're going to give it another minute or so here. We'll probably get started right at 5 after the hour. Give folks an opportunity to click into their Zoom. We are fired up that you are here. This is an amazing event and a very critical time in our nation. So thank you so much for carving out the time from your schedule. We know there's a lot going on, but this is an important event, and you will definitely appreciate the time that you have invested to spend with us this morning. We are going to have the chat bar open, so if you would like to type a message, we will be able to get the questions that you have to our speakers. You are going to have opportunity to control your mute. We would like to be able to leave it open and have as much participation and interaction between our guests and our speakers today as possible. If it does get noisy, we will need to quiet it down, but so far we are having a nice quiet crowd. So thank you so much. All right, ladies and gentlemen, we have hit the hour that we are going to get started. My name is Robyn Peake. I am part of the Republican Women's Federation of Michigan, and it is my pleasure to be able to moderate today's Rule of Law event. At the beginning here, I do want to give a couple quick shout outs. And of course, you know I've got to hit RWFM. The mission of RWFM is to increase the effectiveness of Republican women in government through an active participation and education. We are accepting new members. We have clubs all across the state. Gentlemen, don't feel left out. You can also be an associate member. The website to take a look at to join is rwfm.org. That is rwfm.org. I want to give a shout out to our vice presidential team. We have First Vice President Trish Vega, who is actually stepping up for me while I'm in the process of continuing to recover. She's doing a great job. We have Lana Crystal, we have Donna Clark, and we also have, so we have an excellent team. Those are just the vice presidents that I mentioned. We also have a guest on today from the NFRW, that's the National Federation of Women, and that is Joanne Parker. She is the regional coordinator over Michigan. I also want to give a quick shout out to the Outpouring Cafe, where opportunity to host from this morning. For those who are local, it's a beautiful coffee house and cafe, and definitely worth a stop in to visit for a quick cup of joe or a wonderful feed your appetite. Thank you so much for being here. We are going to go ahead and kick into an amazing event. I've had the opportunity to work with these folks before. It's a little different capacity today, but we are very excited to be able to bring you a powerful woman that you really need to hear from. Her name is Erin Mersino. She is the Chief of Supreme Court and Appellate Practice at the Great Lakes Justice Center. She has written winning briefs for the United States Supreme Court, has practiced in nearly all the federal court of appeals in the country. Prior to working almost exclusively in the area of constitutional law, she began her career as an assistant prosecutor in Oakland County, Michigan. Erin loves her husband, her 5 sons, and the musical Hamilton. She's got so much in her bio. I did want to pick out a couple of quick details for you. She's won a case in the United States Supreme Court. She's litigated several cases before the 2nd, 5th, 6th, 7th, 8th, 9th, 10th, and 11th, and DC circuits. She has worked on some of the most influential cases in recent time, including the Affordable Care Act, which is huge for me as a health insurance agent in my full-time day job. She has just got an incredible background, and she was also a U of M grad from Ann Arbor. She did that in 3 years. She has also attended New York University, Trinity College in Dublin, and taught at the Oakland University Police Academy. Along with her many national television appearances, she is just a powerful lady, a wonderful mom, and a great speaker. Erin, thank you so much for being here with us this morning.
Well, thank you, Robyn. It's wonderful to be with you. Absolutely wonderful to be with you.
Thank you.
So to start us off today, I want to talk about what makes the United States different from the rest of the world. Why is the United States considered the envy of the world? We truly live in the best country, and that is completely due to the wisdom of our founding fathers. They constructed a constitutional republic that is truly of the people, by the people, and for the people, as Abraham Lincoln so famously stated in the Gettysburg Address. Our country is founded on the preservation of freedom, and the rule of law is absolutely necessary, and it's responsible for the preservation of our freedoms. The rule of law is the individual's protection from arbitrary power, and it consists of both protection of the individual from the government aggrandizing its power, and it's also protection of the public official alike. So it works in mutuality. We truly have the best judicial system due to our country's unique application of the rule of law. Aristotle said it's more proper that law should govern more than any one citizen, meaning that our laws shouldn't be made by one person who has power, such as a king, because when one person has so much power, the ability to have corruption is just so truly great. So in our country, in the model of Aristotle, the power is constructed in the rule of law, and we are to follow the rule of law in order to preserve our freedoms and protect our freedoms. So it's a safeguard both against tyranny and against chaos. It protects our unalienable rights. What are our unalienable rights? There are natural inherent rights, such as life, liberty, and the pursuit of happiness. On July 4th, 1977, the Declaration of Independence was brought to light, and we declared our independence from British tyranny. And in this amazingly beautiful document, it states, "We hold these truths to be self-evident, that all men are created equal, and they are endowed by their Creator with certain unalienable rights, that among these are life, liberty, and the pursuit of happiness. That to secure these rights, governments are instituted among men deriving their powers from the consent of the governed. So it is the people who are to construct laws. Our beautiful United States Constitution, executed April 30th, 1789, the preamble to our Constitution states, "We are the people of the United States in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty to ourselves and to our posterity, to our future generations, do ordain and establish this Constitution for the United States of America." Our Constitution is what makes our country different. This is why we've had a constitutional republic for over 200 years, and why other countries have been through struggles and hardships, but we've been able to have these freedoms, which is truly just an extraordinary gift. And I think sometimes, it's easy to take this gift for granted because we are just so extremely blessed in this country. In our Constitution, there's 7 articles, and they lay out a blueprint for the organization of our country's government. And of course, after the Constitution, after it was 3 years after the Constitution, it was ratified, the Bill of Rights was ratified December 15th, 1791. And the Bill of Rights, it's our first 10 amendments, and they establish and safeguard our individual liberties. And today we have 27 amendments. The first 10 are the Bill of Rights. The First Amendment, which is the area of law that I practice in, protects freedom of religion, freedom of speech, freedom of the press. And it states that Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press, or the right of the people to peaceably assemble and to petition the government for a redress of grievances. Within the First Amendment is this concept, and it's the concept of the protection of pluralism. America is a melting pot. We do not all share the same religious views. We do not all share the same desires of what sort of speech we would like to make or hear. But within the First Amendment is this great protection that people in America can have divergent views, that it's acceptable in our country, that everyone doesn't need to follow whatever the king says. People are able to speak freely and think freely. And what a tremendous gift that is. And practice their own religion in accordance with the truth and value of the religion that they choose to practice. It's just absolutely extraordinary. There's a quotation that's been attributed to Voltaire that states, "I may not agree with what you have to say, but I will defend to the death your right to say it." And that is something that truly we need the rule of law to protect, because it would be very easy for a court or a civilization or community to say, we don't appreciate what you're saying, we don't appreciate what you believe, and therefore it needs to be shut down. But in our country, with this rule of law, and with judges implementing the rule of law to protect these freedoms, we've seen that speech is protected regardless of the content of that speech. And an example of this is in the 2011 Supreme Court term. The Supreme Court case of Snyder versus Phelps, a very famous First Amendment case. It was decided 8-1, so almost unanimous. And this is a case where the speech by most people's sensibilities would be repugnant. It was the Westboro Baptist Church, and they would picket and protest the funerals of the American military. And this is very difficult, hard for me to swallow, hard for people to swallow. But what the court did is they followed the rule of law. They examined the facts of the case. The speech took place on public property, and they ruled that it could not be shut down because of the content or the message of the speech, because speech restrictions need to be viewpoint neutral. And that means that speech can't be silenced because the listener does not appreciate the viewpoint of the speaker. And so even though one may not agree with their viewpoint, the viewpoint of the Westboro Baptist Church, their free speech in our American society is also our free speech. And when there's restrictions on the viewpoint of the speaker, then there's going to be restrictions on the viewpoint of the speaker. And that means that one day when we want to speak, if it's not exactly what society wants to hear, but we're doing it in every other legal fashion, we're on public property or we're using a public forum, we can't be shut down because our viewpoint expresses a certain position that we may have or certain thoughts that we may have. And another example of the United States Supreme Court upholding the rule of law would be in the Masterpiece Cake Shop case. This was a baker out of Colorado, and this was a Supreme Court case that was decided 7-2. Again, it was not a closely divided court. And this was a case where the baker, because of his religious convictions, decided not to exercise his free speech to create a cake that violated his religious convictions. So in this case, it was a cake to celebrate a same-sex marriage. And the owner of the cake shop, Jack Phillips, said that because he was a devout Christian, and this man, the facts of the case, he would not even create Halloween cookies. He was very specific in the type of creations he would make at his bakery. And he said that he could not create this wedding cake because it violated his religious principles. The Supreme Court came back 7-2 after examining the record from the Colorado Civil Rights Division and said that in that case, that the Civil Rights Division had actually been hostile in their comments and their examination of his abstention from creating the cake. And so that's another case where you have justices who believe in same-sex marriage, believe that it should be constitutional, and yet when they reviewed the facts of the case and the law in the case, they, after examining it, saw that they had to follow the rule of law, and the rule of law meant that he could object to creating the cake under those circumstances. One of my favorite cases from the last couple terms of the Supreme Court is the Bladensburg Cross case, and that's the American Legion versus American Humanist Association. And this is one of my favorite cases. It's the First Amendment, which is the constitutional provision that I practice under. So it's a passion of mine. But the language in this case I find particularly beautiful because it is the language that our country was founded on the concept of pluralism. And in this case, there was a large World War II memorial, and it was a large cross, or is a large cross. And the American Humanist Association wanted it to be struck down, to remove the cross entirely, because they said it violated the Establishment Clause, that it established a religious view and therefore violated the First Amendment. This is a case, again, it was not terribly close. It was a 7-2 case where you have justices who may believe in the separation of church and state, and yet when viewing the facts and the law in the case, decided that this cross did not violate the Establishment Clause and could remain on the property. And what is so interesting about this case and beautiful is you had even Justice Kagan, who is certainly a proponent of the separation of church and state, and she wrote a concurrence to say that she admired much in the opinion that was written, the majority opinion. In fact, she agreed with it, but also wrote separately. And she quoted the majority opinion, and this is the quote: respect and tolerance for differing views, an honest endeavor to achieve inclusivity and non-discrimination, and a recognition of the important role that religion plays in the lives of many Americans. Here as elsewhere, the opinion shows sensitivity to and respect for this nation's pluralism and the values of neutrality and inclusion that the First Amendment demands. So what beauty is in this opinion, talking about respect and tolerance for different views, inclusivity, non-discrimination, pluralism, our values of neutrality and inclusion. That's what our founding fathers allotted for. That's what's so beautiful about their constitutional design. And my favorite quotation of all time in a United States Supreme Court case is from West Virginia Board of Education versus Barnett. And this is, if there is any fixed star in our constitutional constellation, it is that no official, high or petty, can prescribe what shall be orthodox in politics, nationalism, religion, or other matters of opinion, or force citizens to confess by word or act their faith therein. Therefore, the Supreme Court, and it's been in waves, it ebbs and flows. There are cases where, when applying the rule of law, they have found less in favor of individual freedom and more in the favor of individual freedom. But now, I think after the 2019 Supreme Court term, we've seen more of this influx of preservation of freedom, specifically freedom of speech, freedom of religion. And we're kind of in this era of live and let live. So how can our multi-opinioned, diverse society with very divergent views, how can we live in a society where everyone is allotted breathing space to practice their faith and believe what they need to believe in terms of politics, nationalism, religion, and the like? And this is only due because we are so blessed by having the rule of law in our country. And, you know, I don't believe that many other countries you would see a judge, Supreme Court justice, rule in favor of an opinion that the justice does not hold him or herself, ruling completely contrary to perhaps the political or religious views that that justice has. But the justice is able to do that, and rightly does it, because of the rule of law, the respect for the rule of law. And it's only through the respect of rule of law that we're able to preserve our individual freedoms here.
Can I jump in for just a second?
Of course.
Yeah, so as a circuit court judge for the last 17 years, I've had many cases where I have absolutely a contradictory view on the policy that a particular law might have. It might be a criminal law, it might be something dealing with torts or negligence or governmental immunity, whatever it might be. But when I took that oath to preserve the Constitution of Michigan and the Constitution of the United States, part of that oath is I don't decide policy, I don't make decisions and usurp the authority of the legislature. I follow what they say. Of course, there's an ultimate law of the Constitution, and if the Constitution conflicts, or excuse me, a statute or an executive order conflicts with the Constitution, then I affirm the Constitution. But I'm not making those decisions. I wasn't hired and elected to make policy decisions. If I wanted to do that, I should have ran for state legislature or for Congress, not for judge. So I just wanted to illustrate that point a little bit, because there have been countless instances where I think this is really a ridiculous law, or the consequences of violating the law don't seem fair one way or the other, but I'm constrained by my role to affirm what the law is and not to make a new one up. Thank you.
No.
An excellent point. Thank you so much for jumping in.
Absolutely. And then that gives the legislature the opportunity, if a law that they've created is yielding absurd results, then they can go back and, pass a new law. So there are, so many different checks and balances in our system. And Article 3 of the Constitution requires that the judicial branch interpret the law and not make the law. And this preserves our human dignity. It preserves a person's unalienable rights. And I just want to close with this quotation from Justice John Roberts. This was during the Senate Judiciary Committee. It was on September 12th, 2005. And I love this quotation because it really kind of sums up the role of the judiciary in my view, and what amazing and absolutely excellent judges like Judge Warren practices in his day-to-day life. But judges are like umpires. Umpires don't make the rules, they apply them. The role of the umpire and a judge is critical. They make sure everybody plays by the rules, but it is a limited rule. Nobody ever went to a ball game to see the umpire. Judges have to have the humility to recognize they operate within a system of precedent shaped by other judges equally striving to live up to the judicial oath. And judges have to have the modesty to be open to the decisional process, to the considered views of their colleagues on the bench. That is a remarkable thing. It is what we mean when we say that we are a government of laws and not of men. It is that rule of law that protects the rights and liberties of all Americans. It is the envy of the world, because without the rule of law, any rights are meaningless. Thank you.
Erin, that was beautiful. Thank you so much. There's so many things floating through my head as you were speaking, because we're seeing the rule of law and peaceful protests and freedom of speech and different things like this so under attack right now. And yet we need to maintain the rule of law. What do you see as the biggest challenge right now to maintaining the rule of law in your sphere of excellence?
I think judges, having judges who actually follow the rule of law, elected and appointed, is absolutely crucial. Because if you have a judge who does not apply the rule of law and instead is more acts in the role of philosopher king, then it can be very problematic. And within the system, there are, appellate courts, which provides another, checks and balances. But, once you step away from the rule of law, it's tough to fix.
It opens a whole can of worms, doesn't it?
Yes.
There is one question that came in, and I can open this up to anybody, but we'll start with you. One of our gals asks, is someone going to speak to the misunderstanding and misconception of separation of church and state?
I can do that.
Thank you, Professor Wagner.
Do you want me to do it now or during my presentation?
You know what?
Let me do it during the presentation. I'll weave it in.
Okay.
I'll add it to what I was.
Okay.
I have a question.
Yes.
It's Tom Beckwith. Erin, I know the conversation went over to the rightful responsibility of the legislative branch of government. Seems to me that some of these things are being decided in the courts could be really taken care of in Congress and the Senate. Isn't that true? And you have some suggestions of some laws they might additionally pass, so you wouldn't have to keep running all these freedom of speech issues through the courts.
Well, yes, and I know Judge Warren's going to address the role of the legislature, so I don't want to step on his toes, but in terms of constitutional review of a constitutional right, with the First Amendment, that's something that's redressable by the courts. But there are other matters that would be better handled, in my opinion, by the legislature. So the answer to your question, yes, in short. And I know that area is going to be addressed, so I don't want to go too far into it. But
that's okay. But if I could just jump in here for a second, it is I want to give one example because I think I understand the question, which is that can the legislature jump in and pass some laws that will reduce litigation and take some of these things out of the scope. And this is kind of an analogy, may not be precisely on point, but very, very close. There was a decision written actually by Justice Scalia about free exercise of religion. So I hope I'm not stepping on Professor Wagner's statements that he's thinking about doing. And the decision basically, at least in my view, really did a great disservice to the free exercise of religion. It, instead of using prior tests about if a government action was violating or potentially violating the free exercise of religion, there was this test, a strict scrutiny test about you had to have a compelling state interest, and the interest had to, and the action of the government had to be narrowly tailored. And then in a case dealing with a peyote being used by Native Americans, the Supreme Court said, no, that test doesn't apply anymore. As long as it's a law of general applicability, then you don't need to have this strict scrutiny. So you may have a deeply held religious belief, but if the government passes a law that applies to everybody, you're stuck, and there's no free exercise of religion exception for you. And Congress in the states, it's interesting, Bill Clinton was the president, totally jumped on board with this and said, no, that's wrong. That decision's wrong. So we can't change what the Supreme Court decision is, but we can pass a law called the Religious Freedom Restoration Act, which reimposed on the federal government, at least, that same standard that the Supreme Court had ruled did not apply. And then many states followed up, and Michigan has one, where they say that we're going to hold ourselves, our government, to the higher threshold and the greater protection for religious freedom. So I do think that can happen. And you could also think of many of the civil rights acts that have been passed, where instead of having to rely on the Equal Protection Clause of the 14th Amendment or the Due Process Clause of the 14th Amendment or the Fifth Amendment, that because the acts exist, they kind of settle the issues. So I do think there is definitely room for the rule of law to be embraced by the legislature when they see there's an error coming out of a court system or a gap, they can fill it in. And thankfully, those are positive changes. Of course, the legislature can always try to do the opposite and take people's rights away. But typically, they've been moving forward to protect the individual rights and reaffirming the rule of law.
That's such an excellent answer. And just one little thing, the Supreme Court is going to be revisiting the Smith decision, and that oral argument is going to take place on the 4th of November. And so it may be something that, if you're interested, you could, listen to the oral argument and actually hear, that argument taking place before our nation's highest court. So you may want to tune in.
And you could probably go on the Supreme Court website and read Erin's brief. We did a brief in that case, and she did a spectacular job, I thought. I think, and that's one of the things I just want to mention. Thank you, Erin, for this wonderful presentation. I hope the viewers can appreciate, in addition to her wonderful ability to be able to help us better understand these important concepts that underlie our freedom. Erin's out there every day fighting. Very often in a pro bono and receiving no money, fighting for these this constitutional rule of law and for good governance in the U.S. Supreme Court and other places. And so I just really enjoyed, seeing this side of you, Erin, having worked with you on a daily basis, when you're actually on the front lines fighting. And God bless you for what you do.
Oh, God bless you. Oh my goodness. God bless you. God bless Judge Warren. Oh my
yes.
God.
God bless us all, everyone. Thank you.
I've heard that somewhere.
Yes, we have.
I do have one more question that has just come in on chat. And I'll throw this out there. And if one of you says, hey, I'll pick that up in my talk, like Professor Wagner just did on the previous question, that's great. If you want to answer it now, we can do that too. The question is, can you explain why President Trump can't shut down cities' violent behavior where people are being killed, etc.? Obviously, these are not peaceful protests, and yet there's a governmental structural reason why he can't intervene yet. Can you explain?
I'll take a shot at that. You know, I'm going to talk about the judiciary and the rule of law. And Erin introduced the discussion a little bit by talking about the design of our Constitution. The design of our Constitution separates powers. And what that means, it not only separates power between the Congress and the president, which is the executive branch, and the federal judiciary, but it also separates power between the federal government and the state governments. And the federal government only has those powers that which we, the people, expressly delegate to the federal government in the Constitution. It's a list of enumerated powers. You can go to the U.S. Constitution and you can see what the powers of the president are and what the powers of the state or what the powers of the Congress are. But then in the 10th Amendment, it says to the U.S. Constitution, it says all the rest of the power that's not expressly listed here, you know, belongs to the states and to the people. And so under the 9th and 10th Amendments, if it's not expressly enumerated, then that is left to the states. And so, you know, regulating, you know, the health and things like that generally are considered, you know, state issues. Now, you know, that being said, you know, if a state governor, you know, engages in something that, you know, amounts to the level of allowing an insurrection, then there probably would ultimately eventually be some federal power somewhere for the president to act. I think the reason that he has not at this point is that, you know, it needs to be at a point where there is proper federal enumerated power to the executive branch of the federal government to do that. But the reason that you see these state governors, you know, being in charge, for better or worse, is that, you know, our American Constitution contemplates that unless it's expressly enumerated and expressly given to the federal government, then it's for the states to handle.
Thank you, Professor Wagner. While we've got you, let's go ahead and give you the proper introduction. Professor William Wagner is the chair-elect of the Religious Liberty section of the Michigan Bar. He currently serves as president and chairman of Salt and Light Global. In academia, he holds the academic rank of Distinguished Professor Emeritus. Professor Wagner is an internationally recognized expert in constitutional law and good governance. As lead America's counsel in many matters before the United States Supreme Court, he authored briefs on behalf of various Christian organizations. He also authored written testimony, evidence, and briefs in such forums as Swedish Supreme Court, the US Congress, and the UK Parliament. He has further addressed many executive, legislative, and parliamentary and judicial audiences throughout the world, and presented at various diplomatic forums, including the UN Human Rights Council in Geneva. Professor Wagner's public service includes serving as a federal judge in the United States courts, legal counsel in the United States Senate, senior assistant United States attorney in the Department of Justice, and as an American diplomat. His writing is published in numerous books, journals, and other publications. Soli Deo Gloria. Thank you so much for being here. You've already begun contributing, and I'm excited to hear more of what you have to share with us this morning. Professor Wagner, the floor is yours.
Thank you. It is a privilege to be here, and, you know, welcome to everybody who is taking time from this beautiful Michigan day out there and participating here. You're here because I believe that if you're taking this kind of time and listening to this kind of message, that you care about our nation, you care about our state, and you care about how our government is supposed to work. And so I thank Judge Warren for, you know, organizing this and putting this together. And my topic for the day is the judiciary and the rule of law. And as I mentioned earlier, Erin had talked about how our constitutional system anticipated a design, and it designed our government by separating powers, and that way no one branch can take actions that infringe on our liberty. Separation of powers are actually designed as a way of protecting our individual liberty. Think of freedom of speech and your free expression and the free exercise of your religious conscience and your right to due process. All these things, are grounded in an idea that was expressed in our Declaration prior to our Constitution. We hold these truths to be self-evident. That all men are created equal, that they're endowed by their Creator. That's a capital C, with these unalienable rights of life and liberty. And these are limitations on the exercise of government power. Now, the structure of separation of powers, certainly doesn't make governing easy. I suppose if you're a dictator, you can get things done pretty quick because, one person, one branch says do this and it gets done, or somebody's, head rolls literally. Now, our founders understood that, though, in that it was a lot more difficult to infringe on individuals' rights, your citizens' rights, if the government can only act where there is more than one, person, more than one branch, acting at a time. So there's almost, in a way, a strong presumption against, government action. Dictators can be really efficient folks, but only at the expense of your liberty. And it's an idea that the less we have government interfering, the better for our freedoms. Now, this is a question that's been debated for many years. Why make change more difficult? Why shouldn't we have an unelected federal judge be able to just dictate, public policy on a particular issue and say, hey, that's the way it's going to be, and I'm wearing a robe and I've got ink in my pen, and so therefore you're gonna follow my judicial, opinion? Why should our nation that believes at the bottom of its soul in majority rule, in governance by the people, for the people, why should we, choose to stay with this, covenant, this idea of a constitutional process that we made over 2 years ago that was designed in a deliberate way to make things more difficult? Why shouldn't, a judiciary, for example, that's not elected, be able to, decide to make policy and get things done? Hey, we need to have, a right to abortion, and we can't get enough people in the country to agree to it. So let's get, a number of judges wearing robes with ink in their pen to decide that, hey, we can have this right, and we'll just add it to the Constitution. Somebody talked about separation of church and state. Well, wow, the Constitution expressly, doesn't say anything, doesn't require separation of church and state at all. In fact, any separation of church and state that is, if you study this, that's actually in the Constitution, is there to stop the government from interfering with churches. And yet you've got governments right now, as we're sitting here, fining churches out in California $60,000 at last count I saw, because they are singing, or worshiping God through their voice, at a church, and so why make change more difficult? Why require separation of powers? Why limit the power of the judiciary to just deciding cases under the rule of law, a rule of law that is made by people that are representatives of those who vote? And so the idea under the separation of powers is that policy is supposed to be made by representatives of the people in your legislative branch. And the reason for that is if you don't like the policy, that in the next election you hold a job performance review, and you either fire them or you rehire them to be your representative again. in the judiciary, you know, they're supposed to take these rules of law that are given to them by the people's representatives, and then when a dispute arises between people, take that rule of law, apply that rule of law to the dispute to resolve the dispute, and then allow, okay, now we know we're going to have something that people can rely upon. They can go look to that law and they can choose to violate it and act outside that law, but they know that there's a cost because the judiciary is going to then, if there is a dispute, apply the law and resolve it in a way based on what the law says. And let me pause here so that you can write this down, not based upon what the judge prefers the law to be. Mm-hmm. Too often we have unelected judges and judges that, you know, don't like the law. They have a dispute that comes before them. And so they say, wow, if I resolve this dispute in using the law the way the legislature gave it to me, I'm not going to get the winner I want. And so, or I don't like the public policy behind the law as it's written. And so the judge decides to, you know, rewrite the law. And this is most dangerous when it gets to a Supreme Court, state Supreme Court, or a U.S. Supreme Court level, where a particular group of judges do not like what the Constitution says. And so therefore, instead of allowing the people to amend it through the process that the Constitution provides for, they just decide to add a right here or there, or to you know, diminish a right that is already in existence, you know, specifically and very expressly and clearly articulated in the Constitution. And they don't like that, so we'll just diminish it and we'll reinterpret it to mean something other than what it actually means. Now, our framers understood the corrupt nature of the human spirit. You know, we're not born good, contrary to, you know, what, you know, you may have been told in the last 25 years in our public education systems these days. But we know that if you've ever raised a kid, that we're not born bad. You know, and I've told a story 100 times. Some of you have probably already heard it, where if you have a rattle and you give a rattle to a little child, and the little child's playing with the rattle, and a second child wants to participate in the rattle playing, the first child doesn't walk over and say, "Here, let me share this rattle with you. We were all born good and I want to share and we can have fun together." Well, no. In fact, if the second child wants to participate in the rattle playing, that first child's going to grab that rattle, hold it to her chest and say, "No, it's mine." And I've told that story throughout the world, and it doesn't matter the culture you're in. Everybody understands the inherent nature of humans. And those, you know, babies that say it's mine, you know, that rattle's just like power when they grow up. And if you give any opportunity of any particular public official, you very often see, you know, the exercise of power in that same way. And so our framers understood that corrupt nature of humans, especially with regard to governing, and to prevent tyranny of the majority, especially in a time of crisis. And as we are dealing with this, you know, COVID issue, they expressly had these, they put the structure of separation of powers and the limitation of the exercise of those powers in place, especially for times of crisis, because they understood that in times of crisis, that's when humans can, you know, really take advantage and take an opportunity to exercise power corruptly. And so that was part of the job of the judiciary, was to preserve our liberty and to prevent tyranny by, you know, these other branches of government during times of crisis. Why and how? By looking specifically at the constitutional rules of law that limit the exercise of government power. And then when government steps over them, and like they always do in times of crisis, say, no, wait a minute, we've got something in the Constitution that says you've got to have due process. If you take somebody's property, you have to give them just compensation. If you interfere with private contract, you're violating the Constitution. If you interfere with the freedom of speech, you're violating the Constitution. If you interfere with the free exercise of religious conscience, you're violating the Constitution. So to prevent tyranny of the majority, and as well as to prevent tyranny of the minority. And when I talk about that, I'm talking about they've designed the structure of our Constitution to prevent a judiciary, a few judges wearing robes with ink in their pen, to be able to say, we are going to substitute our will for the will of the people. Now, it's important that we understand that proper role of the judiciary within the constitutional order. Robert Bork wrote, and I don't want to read too much here, but I want to just read you one little analysis of his observation. He says the judiciary's great office is to preserve the constitutional design. He understood that our constitutional process only works if everybody, the legislature stays in their lane, the executive stays in their lane, and the judiciary stays in their lane. As soon as the judiciary wants to start, making law like the legislature, now you've got a problem. Now you've got a tyranny problem, because now you've got someone who is not represented by the people, not somebody who was elected by the people, nonetheless making policy. And at the federal level, not having to be held accountable for that policy at the next election. And so, if we understand the proper structure of our American constitutional system, that it contemplates a judicial branch with absolutely no power to make or enforce laws, we're going to get along fine, and we will have a much smoother, I would suggest that we would have exponentially less conflict than we currently do. We all know, we don't have to pretend, we can talk about the elephant in the room right here. Our nation is divided more than it's ever been divided before. And I'm going to suggest that that is happening for a number of reasons, but one of the biggest reasons is because we have judiciaries, and especially a federal unelected judiciary, making public policy and not that much of the nation disagrees with, and then depriving the nation, the people of the nation, from being able to hold the policymaker accountable. And had the judiciary in the last 75 years stayed in their lane and decided disputes under the rule of law, and when I say under the rule of law, based on what the Constitution actually says, based on what the legislature and Congress actually says, we would have much less division in this country, because then all of these really tough issues that divide our nation, like abortion and same-sex marriage, and all these things that have been divided by that have been decided and made public policy by unelected judges who never have to face an election, those issues would have had to go before the people's representatives. And would have it been tough? Yes. Would have it been much more difficult? Yes. Would have there been winners and losers? Yes. But the losers would have been participating in the process, and they would have understood the process as legitimate. And when you lose in a process in which you were allowed to participate, and you were allowed to participate in what is recognized as a lawful process, those public policies have much more legitimacy and acceptance, even by those who end up not winning the public policy battle. So it's my view that judiciary, needs to stop, and they must never usurp the people's prerogative when interpreting constitutional and statutory provisions. If they look to a constitutional provision and they have a statutory provision that applies to a dispute that's before them, and we need to apply that rule of law to resolve the dispute, don't change the law just because you don't like it. Leave that to the legislature, leave it to the hard work of the people and their representatives, to get it done. Our founders understood what happens when you don't do that. Deliberately usurping constitutional amending process, undermines Republican governance under the rule of law. And when I say Republican, I'm not talking about the Republican Party. I'm talking about that we in this nation, the kind of government we are, we're not a dictatorship, and I know many states would question that these days, but we're not a democracy. We are a republic, and a republic is a democratic representative form of government where we elect through a democratic process representatives who make the public policy, and then we hold them accountable in the next following, election, after that. When an unelected judiciary or even an elected judiciary usurps the constitutional amending process, that undermines that representative form of government. Why? Because if a federal judge decides to change the Constitution, to add a right or to diminish a right, and once again, let's talk about, somebody asked the question about separation of church and state. I'll use that as an example. The Constitution says Congress shall make no law respecting an establishment of a religion. Very clear. You know what the word establishment means? We can look it up in the dictionary back in the 1800s. It means the same thing back then than it means right now if you look it up in a dictionary now. And it says that the government cannot establish, a religious government. And we know what that means. Well, if you are a judge that doesn't like, that wants to extend that and have it to mean much more than that, and say that not only must not government establish, a religious government, something like, Sharia law, or say that, we have to have a Christian government and all, or a Jewish government or a Islamic government, and all legislation must, match those, religious tenets. There are religious governments like that. You can go around the world and I can show you Arab constitutions that say exactly that. Our Constitution says just the opposite. It says Congress shall establish, no religion gets to establish their religion as the government. But we've had judges that say, well, we want to go further than that. We want to say that that it must have a secular purpose, and that every government action must have a secular purpose, and it must not even symbolically endorse a religion. Well, that's two very different limitations on the exercise of government power. If you take what the Constitution actually says, say you've got a cross that is a cross that's in a public park or something. Does that establish Christianity as the official government religion of the United States government and require all public policy to, be in line with Christian tenets? No, it does nothing of the sort. So therefore, it doesn't violate the First Amendment. But if you take the new meaning of establishment and say, and you look at this, what the Supreme Court did, they said, well, there's this separation of church and state, and therefore you have to have a secular reason for everything you do, and you can't symbolically even endorse, religion. Well, certainly a cross on a public land, at the very least, symbolically endorses a religion. So that now it's considered unconstitutional, even though the constitutional provision that it's being ruled unconstitutional based on says nothing of the sort. We're ruling it unconstitutional because unelected judges, have decided to add this separation of church and state that doesn't exist in the Constitution. So, if we want to change the Constitution to require that every government purpose have a secular purpose, there's an amending process in Article 5 of the Constitution that allows the people to do that. Now, that's going to be a lot more difficult. And so, people that don't like Christian people and don't like religion and, say, I don't want to go through that process. I'll just find me a friendly judge that has a robe and I'll get them to change the process. And they won't be able to do anything about it and the people won't be able to do anything about it because that judge won't have to run for an election. So see, that's the big deal when we're talking about the rule, of law and the judiciary. Why do we have separation of powers for the judiciary? We want to give judges independence. We don't want them to be political. One of the biggest concerns we had in the formation of the nation when we put the government together was that judges be able to be independent. They were afraid that if judges have to decide a dispute, if they didn't use the rule of law, then they would, be probably making a decision based on politics, because they would want to be able to keep their position as a judge. And if they were going to be forced out politically, and make a decision on who should win a case in front of them based on politics so that they could keep their job, that does not help good governance under the rule of law. And so what we did when we set up the judiciary is we said we're going to give judges independence. We're not going to have them run for an election at the federal level. And that independence is going to allow them to take the law as Congress gives that to them, decide the case based on what the law actually says, and then if the people don't like that decision, well, then they can take it up with Congress, their representatives. That's the way it was supposed to work. When the judiciary abuses that independence that it's been given them and decides, I'm going to advance a public policy position that I prefer instead of the one that I'm reading in front of me, that threatens the judiciary's institutional legitimacy, because now the judge is acting outside their lane, and they're acting outside outside a constitutional process that the Constitution allows. And the reason that we have the rule of law and that we ask judges to follow the rule of law is because we want predictability. If somebody enters into a contract with somebody to sell a car to them, and the person says, I agree to give you money and you agree to give me the car, if either one of those people break their promise, that's called a breach of contract. Contract law says that if you breach your contract, you're going to be held liable to the party with whom you broke your promise to. That provides predictability. And so that's why we have the law. That's why we have the rule of law. And so if somebody, they can choose to follow the rule of law or not with regard to whether they're going to follow the contract. But if they choose to not follow the law, we have predictability in a society that this other side can now bring a lawsuit against the person who lied to them, who breached the contract, and we have some predictability on the way the law is going to have an outcome. That's a big deal, because I worked in helping nations in Africa, rebuild after civil war, and one of the things you want to do was you want to be able to bring businesses in and have them engage in contracts where they would, rebuild the economic infrastructure. Well, if a promise isn't worth the paper it's written on, and there's no predictability that the judge is actually going to enforce the contract as it's written, but they're going to instead decide who wins based on who gives them the bigger bribe, you've undercut the rule of law. And likewise here in the United States, if you start to decide cases based on what you prefer the law to be as a judge, as opposed to what the law is, now you've undermined and the predictability of the law that we, the people, rely on in our everyday affairs. I'm running out of time here, I think, so I probably should have a pause and maybe open up for questions.
Perfect. Yes, yeah. We do. We have several questions. I'm going to go kind of in order of the most recent question that came in, and we'll backtrack a little bit. In the situation that you just mentioned, where the judge is interpreting based on their own preference or who gave them the biggest bribe, the question was asked, who blows the whistle on the judge? What do we do to rectify that situation?
Well, in days past, and increasingly it's many days past, we could rely on the media to do that. That was, part of what the media did. It was, not a fourth branch of government, but one of their roles was to be a watchdog. As the media increasingly becomes players in a larger political game here. Neither side, relies on certain media outlets, for depending on which side you are on the political spectrum, you're not going to trust, what you're reading in the media. So unfortunately, one of the biggest ways that we used to be able to hold judges accountable, we're not able to, trust, that much or whether we can or not, the people don't necessarily trust them anymore to be able to do that. And so that makes us fall back on the Constitution. And those separation of powers become very important again. And I'll stick with the federal level, but there's a different conversation that also applies at the state level as well. Each of the state constitutions and the federal constitutions, in the separation of powers, they give both the legislature and sometimes the executive, depending on where you're at, checks that they can use to check the judiciary. And so, for example, if the people's representatives, Congress, for example, feels enough pressure from their constituents, they have ways that they can check the judiciary. Number one, they've got the appropriations power. They can't lower the judges' salaries because the Constitution prohibits that, but they can certainly decide that you don't get to have a fancy mahogany desk, and you don't have to have a law clerk, and you don't have to have all these paper clips we buy you every year. There's the appropriations process that can check the judiciary. There is also a provision in the American Constitution that allows the Congress to strip the federal court judge of certain kinds of jurisdiction to hear certain kinds of cases. And Congress from time to time has exercised that power. That is a very effective way of say, hey, judge, wake up, get back in your own lane, or we're going to start stripping jurisdiction from you to allowing you to hear certain kinds of cases. And finally, there is always what I call the hammer. Congress has the power of impeachment, and the House of Representatives can impeach a federal judge, and the Senate of the United States has the power upon impeachment to remove a federal judge.
Wonderful. Thank you. The next question up is, we know that you mentioned Article 5. This person mentions Article 6. We know that there is Sharia law that is in direct violation to Article 6 of the Constitution, and the Muslim faith is part of Sharia law, or the Muslim social movement, I guess you would say. The two are inseparable. Why doesn't Congress bring this to light?
I think, and I would actually go more to the First Amendment and look, and I understand what he's saying with the Article 6, but the First Amendment prohibits governments from establishing a religious government. And if you talk to, and I have talked to imams, and I've talked to different people, they have, in an honest moment, conceded that the First Amendment would have to be amended. And part of the reason that Congress hasn't done what the questioner has suggested here is, I think, mostly out of ignorance. They don't understand that, Islam is a religion, but it's also a political system. It's a government. Unlike Christianity or Baha'i or some other religion that is a religion solely, Islam by its very nature is a way of, it means a way of life. It is a actual political system. It is a government. So when you're establishing a religious system, you're not just establishing a mosque, you're also establishing the basis for a religious government. And so part of it is that we the people don't always understand everybody's culture as well as we perhaps should, as well as we understand our own. And so that would be my answer, I guess, to the person that filed the question. It's just I think it's more of a lack of understanding more than a lack of political will.
Okay, thank you. And lastly, before we move to our next segment of our time together today, this statement came in. Government officials, federal, state, and local, attack its citizens in unconstitutional ways using taxpayer funds, but citizens must use their own personal funds to defend themselves. If the government loses, they can spend more taxpayer money to appeal. This is not a level playing field. Can we change this?
There is a lot of places where it's a unlevel playing field, especially in Michigan with regard to some of the things that unelected commissions can do, and then force you to expend money, as you said. But there is at the federal level 1983 actions. They're called 1983 actions, and where a government is interfering with your constitutional liberties, and you can prove that, and I don't want to get too deep in the weeds here, and you ultimately prevail, you can gain attorney fees, recover attorney fees. We recently had a case where we didn't begin to recover all the attorney fees that were expended, but the federal government, but we at least recovered some, because the case was brought under Section 1983. And Erin was very, God bless her again, very impactful and part of that. So hope that answers the question. The other answer to the question is in places like Michigan, where you've got these these little fiefdoms, I call them, and perhaps designed originally with good intent and good hearts. People inevitably exercise power in ways that abuse power, and all of a sudden you're found. We're representing a number of businesses right now that are being investigated for violations of laws that don't even exist yet in Michigan, but yet you've got government officials coming after them, and they've got to do something. And so so that I think, again, the only resolution that I see at this point is statutory reform, and that's the people through their elected representatives changing some of these things.
Thank you. I really appreciate your wisdom and your insight on this. Keeping an eye on time, I'm going to give you a chance to take a sip of water. I know you've shared a ton of knowledge with us. Let's move over to our host for the day. Judge Michael Warren has served on the Oakland County, Michigan Circuit Court since 2002. He's co-founded Patriot Week, which is www.patriotweek.org, with his then 10-year-old daughter, Leah. He authored the America's Survival Guide, How to Stop America's Impending Suicide by Reclaiming Our Founding First Principles, which is available at www.americassurvivalguide.com on Amazon and other online retailers. He is the host of Patriot Lessons, American History and Civics podcast, as well as Patriot Lessons TV show. He teaches constitutional law at Western Michigan Cooley Law School, authored constitutional law surveys for Wayne Law Review, and is the originator of several legal reforms. He is the former member of the State Board of Education of Michigan. Judge Warren was honored as the Judge of the Decade in 2019 by the International Association of Top Professionals, among other awards. You've already heard a little bit from him. Now we get to turn the microphone over to Judge Michael Warren. Thank you for being here with us and for hosting today.
Well, thank you, Robyn, and I want to thank my co-presenters, Professor Wagner and Erin Mersino. They're fabulous and awesome, and it's going to be hard for me to keep you folks awake after you've heard such stimulating and engaging discussion from them. And I'm going to start with something that about why it's important that we're having this today. And I want to go to the Annenberg Public Policy Center's Civic Knowledge Survey in 2019. It found that only 2 in 5 American adults, 39%, could correctly name the 3 branches of government. It's not that hard, right? There's a legislative, executive, and judicial. Only 39% of the people could understand that. And 20% could name exactly 0 branches of government. Now, we don't have a dictator, we don't have a king, we don't have a communist party or something that's running our lives. We're in charge of the government. The government's supposed to serve us, not the other way around. But if we don't have even the fundamental understanding that there's 3 branches of government, we are quite frankly doomed. So that is why it's so important that we're here today to remind people about the importance of the rule of law, the differences between the branches, and trying to renew the spirit of America. So I want to thank everyone that's watching either on Facebook Live or on the Zoom call for your deep engagement and desire to learn. And I would really recommend that you work on becoming an ambassador for civics and constitutional education with your friends and families, and you can direct them to this particular rule of law forum or to Patriot Week in general, or my book, because it's so desperately needed. Now, Article 1 of the federal Constitution establishes the legislative branch, which that is the Congress, which is composed of a House of Representatives and a Senate. Again, basic Civics 101, which I'm not sure that many of our folks really think about. Article 2 of the federal Constitution establishes the executive branch, and that's almost the one that gets, at least in these days and times, almost all the attention. That's the president. And Article 3 establishes the judicial branch, that is the Supreme Court, and lower courts is established by Congress. We've heard about the importance of the rule of law with regard to the judiciary, and why the rule of law is important in general, and why it's important in connection with the legislative and executive branches is the question that I'm addressing. Well, first things first, our federal and state constitutions are actually written down. You might think, well, that's obvious, who cares, you know? But au contraire, that is a relatively recent development in the course of human history. In ancient times, up until 1776, almost no governments were established with written rules. England, for example, had an unwritten constitution, and there were very few exceptions to that, like the Magna Carta and a Bill of Rights, but they really didn't define the whole Constitution. They just defined a few areas of protection. It was not a written plan of government. Now in America, when we declared independence, we put it in writing. First in a resolution of independence on July 2nd, 1776, and then we adopted the Declaration of Independence on July 4th. Then that started to firmly establish the precedent that Americans would define their rights and the form of government in writing. The individual states began to adopt written constitutions. Some had done just before the Declaration of Independence, but eventually they all adopted a written constitution. And then the federal government was established by a written constitution, and then the newest, first there was the Articles of Confederation, and finally there was the Constitution as we know it today. It was drafted in 1787 and came into effect in 1789, as Erin had alluded to earlier. The ratification process was extremely important. The founders debated the purpose, meaning, origins of literally each word in the proposed Constitution. And the Constitution was adopted by constitutional conventions held in each state, with the people electing delegates to attend the Constitutional Convention to decide whether or not the states would ratify the Constitution. And they did so by debating the written text. So the text was what was controlling. For the legislative branch, the rule of law is important because it defines what the Congress is. The Constitution provides who is eligible to serve in the House and Senate, how they are elected to each of the houses, the powers that Congress has, and the powers that Congress does not have. If the Congress violates rules, procedures, and limits on the powers that are defined by the Constitution, it is violating the will of the people. It's subverting the fundamental law and usurping authority of the people on its own whims. And it fails to act when it has if it fails to act when it has the responsibility to act, it does the same exact thing. So let's take a few examples. The Constitution defines who can be a member of the House of Representatives as follows. No person shall be a representative who shall not have attained to the age of 25 years and have served 7 years as a citizen of the United States, and who shall not, when elected, be an inhabitant of the state in which he has been chosen. Now, let's say a person runs and wins an election for the House of Representatives in California, but they really live in Michigan. She's 21. She's a Canadian citizen. The Constitution has this other provision. It says the House is responsible for the qualifications of its members. Now, let's also say this person, this 21-year-old Canadian, is a huge pop star. And the people in California love her. And they really want her to serve. And she happens to be a member of the majority of the political party in the House party, the party that's in control of the House. And she also donates a lot of money to that party. And so they really want her out there. And so the House says, come on board. We're gonna let you serve in office. There's 3 reasons why she's not qualified. Doesn't matter. The House says we're gonna let her stay as a member. That obviously completely undermines the rule of law. It puts a stake in the heart of the Constitution for temporary political gain and greed. Another example involves doing something that's specifically prohibited. Professor Wagner mentioned this. Article 1, Section 9 of the Constitution has a list of specific actions that the founders decreed that Congress should never do because they strike at the heart of liberty. Actually, I'm not sure that he mentioned this one. So Article 1, Section 9 is a bunch of things that you can't do as Congress. One example is ex post facto laws. That's a Latin phrase, which basically means making something that was legal when you did it, illegal retroactively. So let's assume for a moment that a new plague hits the United States on August 28th of 2022. We're going to go way in the future. And after doing some research, the scientists trace it to a certain coffee crop that was imported from Zambia. And they figure out that the people that imported the crop knew that there was a risk of this plague, but they ignored it. But at the time, it was legal to import the coffee, regardless of the risk. Okay, so they did something perfectly legal, even though maybe it should have been illegal, but nobody knew. So on January 1st, 2023, so 4 months after the plague hits, Congress decides to attack the epidemic, and they punish people by declaring the importation of the coffee crop a crime beginning back on August 1st of 2022. In other words, they make something that was perfectly legal in the past, when they did it, a crime. As mad as Congress might be at the coffee importer, that would violate the rule of law. It strikes at the heart of liberty, because we've made a decision that we're not going to allow Congress to retroactively criminalize behavior. And to do so otherwise subjects everyone unfairly to criminal penalties at the whims and passions of the Congress. Let's take another example. The powers of Congress, as Professor Wagner mentioned, are expressly defined in the Constitution. And this is called the doctrine of enumerated powers. Most of the powers of the federal government are listed in Article 1, Section 8 of the Constitution. If it's not listed in the Constitution, the federal government is prohibited from doing it. Those powers are left to the states through the 10th Amendment, and also just by the way the Constitution is written. The list is not that long. The Congress shall have the power to lay and to collect taxes, duties, and imposts, and excises, to pay the debts and provide for the common defense and general welfare of the United States. But all duties, imposts, and excises shall be uniform throughout the United States, to borrow money on the credit of the United States. Now we got like $23 trillion in debt, so maybe we should relook at that, but we can do that now. To regulate commerce with foreign nations and among the several states and with the Indian tribes. To establish a uniform rule of naturalization and uniform laws on the subject of bankruptcies throughout the United States. To coin money, regulate the value thereof, and a foreign coin, and fix the standard of weights and measures. To provide for the punishment in counterfeiting the securities and current coin of the United States. To establish post offices and post roads. Yes, there is a postal power. To promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to respective writings and discoveries as patents and copyrights. To constitute tribunals inferior to the Supreme Court. To define and punish piracies and felonies committed in the high seas and offenses against the law of nations. To declare war, grant letters of marque and reprisal, and make rules concerning captures on land and water. To raise and support armies, but no appropriation of money to that use shall be for longer than 2 years. To provide and maintain a navy, to make rules for the government regulation of the land and naval forces, to provide for calling forth the militia, to execute the laws of the Union, suppress insurrections and repel invasions, to provide for organizing army and disciplining the militia, and for governing such part of them as may be employed in the service of the United States, reserving to the states respectively the appointment of the officers, the authority of training the militia according to the discipline prescribed by the Congress, to exercise an exclusive legislation in all cases whatsoever over the district, and this is the Washington, D.C. provision, I won't read it all, to make all laws which shall be necessary and proper for carrying into execution the foregoing powers and all other powers vested by this Constitution, the government of the United States, or any department or officer thereof. Okay, it was a little long. It's like maybe 2 minutes. There are huge swaths of the federal government, of what they do today, that is not in that list. And that's a problem. When Congress acts, it needs to be linked specifically to one of the powers that I just listed, or the action is unconstitutional. Because, as Professor Wagner mentioned, the 10th Amendment reserves all other powers to the states. So I'm going to use a real life example. Congress passed the Affordable Care Act, otherwise known as Obamacare. Congress passed a law requiring people to buy health insurance. The Congress claimed that they had the authority to regulate interstate commerce. Because they had that authority, there's no dispute about that, that it had the authority, their argument was, to compel interstate commerce. And the Supreme Court, in a very slim 5-4 majority, blanched and struck down that provision. In the majority opinion written by Chief Justice Roberts, the court held that the individual mandate does not regulate existing commercial activity and instead compels individuals to become active in commerce by purchasing a product on the ground that their failure to do so affects interstate commerce. Construing the Commerce Clause to permit Congress to regulate individuals precisely because they are doing nothing would open up a new and potentially vast domain to congressional authority. Everyday individuals do not do an infinite number of things. In some cases, they decide not to do something. In others, they simply fail to do it. Allowing Congress to justify federal regulation by pointing to the effect of inaction on commerce would bring countless decisions an individual could potentially make within the scope of federal regulation, and under the government's theory, empower Congress to make those decisions for them. The government's theory here would effectively establish that individuals may be regulated under the Commerce Clause whenever enough of them are not doing something the government would have them do. Indeed, the government's logic would justify a mandatory purchase to solve almost any problem. And it goes on and says it would basically turn the Constitution upside down, giving the federal government unlimited authority. So the Supreme Court said, no, Congress acted beyond its means. To regulate interstate commerce does not mean to compel it, and so it struck that down. And lastly, the legislative branch can violate the rule of law by not doing something that it's responsible for. Although it's really not been invoked effectively in the recent past, in ALA Schechter Poultry Corporation versus United States, the United States Supreme Court held that Congress is not permitted to abdicate or transfer to others the essential legislative functions with which it is thus vested. In other words, the legislature has to legislate. It's its job, it's its duty. It cannot delegate or give away legislative powers to the president. You can't just say, Mr. or Mrs. President, you can have all of our power. There are these 4 vitally important constraints of the rule of law are applicable to Congress. That again is defining who can serve in Congress, defining the powers that Congress has, defining the powers that Congress does not have, and requiring the Congress to act as a legislative body. These all have similar analogs in the states. Generally, state constitutions define who can serve in the legislature, the authority of the legislature, what they can't do, and they also encompass the non-delegation doctrine. Now, the COVID-19 epidemic is a place where these issues are kind of all clashing. Many governors, for example, have issued emergency decrees. Some of those governors are claiming authority under broadly written laws that basically allow the governor to act as a legislature in times of emergency. But now, it's been months and months, and questions are swirling around whether those governors' actions really fall within the law, if there is a law, and that they're claiming authority from, and whether the legislature had the authority or was barred from passing emergency-type laws that would so delegate their authority to the governor. So this would be fascinating to watch. If we are to maintain our constitutional order, the legislative branch must follow the law. Likewise, the executive branches of the federal and state governments must abide by the rule of law. The Constitution vests a set of powers in the president. The president has the obligation to follow the limits on that authority and also has the obligation to fulfill them. For example, the president can make treaties, but only with the advice and consent of 2/3 of the United States Senate. So let's say a president desperately needs a political victory and knows that he or she cannot secure the 2/3 vote he or she needs to enter into a very controversial arms control treaty. And so instead of going to the Senate and saying, approve this and losing that fight, he enters into the treaty without the Senate. That would totally undermine the rule of law and the constitutional order. Likewise, the president is to be compensated the same amount during his term of office. That's actually in the Constitution. In modern times, the president has a salary that cannot be increased or decreased during his term. So let's say he decides he needs a raise and he wants an extra $1 million a year. And so he goes to the Treasury Secretary and says, take $1 million. It's nothing in the federal budget. We got trillions of dollars. Just give me an extra $1 million this year. That would fly in the face of the rule of law, right? Not allowed to do that. Remember, the Congress and the state legislatures are to make the law, and the president and the governors are to enforce it. The more executive action looks like a legislative action, the more likely it is to be violating the rule of law. One area of great constitutional uncertainty and controversy is the use of executive orders by the presidents and governors. The federal Constitution is silent and never uses this word, executive orders. But George Washington did issue a few important executive orders. He issued a total of 8 in his 2 terms. In the 20th century, the use of executive orders has exploded. Teddy Roosevelt really was the first president to dramatically increase their use. Before that, the most that was ever issued was 217 by President Grant, and that was in the wake of the Civil War. But Teddy Roosevelt issued 1,081. President Wilson issued 1,803, and FDR issued 3,721. Then it kind of goes back down and plummets, and they kind of stay in the low hundreds. And even under Clinton, it was 364, George W. Bush, 291, Obama, only 276, and there's been less than 200 under Trump in his first term. Initially, executive orders were really directed at specific agencies to direct them to undertake certain procedures and processes. In other words, they were managing how a policy directive of Congress was to be undertaken. It wasn't creating new policy. It was just how do we manage that, which is what Washington's first executive order was. Would you guys please tell me what you think we should do with the government? I mean, that's an order. I mean, it was kind of like a request for advice, but it was an order. We have increasing scrutiny more recently because recent presidents seem to be acting not in a managerial role, but in creating policy to circumvent Congress. President Obama famously said that if Congress did not act in an area that he really wanted to act, that I am going to be working with Congress where I can accomplish this, but I'm also going to act on my own if Congress is deadlocked. I've got a pen and I got a phone, and I'm going to rally folks around the country on this mission. Now, many have argued that Obama and Trump executive orders have overstepped the bounds of executive action because they are infringing on Congress's lawmaking ability. And I'll leave the merit of that, but I think it's really important to understand that that issue is really coming to the forefront. In America, we do not have kings or nobility. The executive is a creature of the applicable Constitution, and their powers are defined by the written instruments. We cannot succumb to the temptation of supporting executive actions just because we like the policy. It must also fall within the constitutional authority of the executive. In the end, executive officers need to respect the Constitution, even when this is very frustrating. The rule of law is essential to preserving our constitutional limits and our liberties, and it's absolutely essential that the legislatures and the executive branch maintain the rule of law by respecting their constitutional bounds. Thank you. God bless you, and God bless America.
Thank
Hey.
you so much.
Thanks. May I add something with regard to executive orders of the president? there is a very big distinction between the language in Article 1 that gives legislative power to the legislature, where it says, all legislative powers herein granted, very specifically, these are the specific powers and only these powers you have, legislature. Compare that to, that's what it says in Article 1. Compare that in Article 2, where it talks about all executive power is in the president, is in the presidency. And so that very different kind of language has been looked at by a number of judges and scholars to affirm that that a president does have an immense amount of executive authority. Now, where that authority ends is a question. I think you're right, Judge Warren. But certainly the difference in the way that we, the people, wrote those two power delegations, certainly suggests that a president does have power to issue these executive orders. Hope that helps.
Absolutely.
Judge Warren, while we have you on screen, did you happen to see any questions from our Facebook Live audience that we need to address?
They have been very quiet. We've had a lot of people come in and out, but they've been very quiet with regard to questions. So thanks for asking.
Thank you so much for having the Facebook Live group on with us.
Absolutely.
Ladies and gentlemen, I do want to turn your attention towards the chat box. We do have the websites up for patriotweek.org, americassurvivalguide.com, RWFM.org, and saltlightglobal.org. So you can access these resources even following our event today. I want to be able to make sure that you have access to that. Judge Warren, did you want to have a last comment, or are you ready for me to switch it over to our next speaker?
Oh, go to Erin, please.
All right. Coming full circle, ladies and gentlemen, we have one more opportunity to hear from the lovely and powerful Erin Mersino.
Thank you. So I'm talking about the rule of law and individuals. So when thinking about this topic, two things came to mind: responsibility and benefits. So America is unique and distinct because I think as a country, we have one of the greatest principles of individualism and liberty known, period. And our Constitution is so amazing that it protects, it doesn't regulate or destroy our natural rights as men and women. So when we're talking about our individual freedoms and our role as individuals in accordance with the rule of law, in America, we have a very strong rule of law, and we are an example to the world as to how to apply the rule of law to have an orderly society that also insulates our natural rights. And our rule of law enhances our lives. When you look at just our day-to-day life, I am able to make my kids' wishes come true by getting them in the car and driving them to McDonald's. That's one of their favorite things to do, is eating horrible McDonald's junk food from time to time. And I'm happy to oblige because of how happy it makes them, and we don't do it every day. But we're able to go down the street, and people generally obey the traffic laws to the best that they can, generally. I go and I get out, the $20 bill of United States currency, and I'm able to give it to the cashier at McDonald's, and she accepts the money because we have this rule of law where it's respected. And the food that we get is going to be, regulated. It's not going to have, anything terribly unhealthy. I mean, it's not healthy food at McDonald's, but it's going to be certainly edible, not poisonous. and the prices on the menu are going to be the prices. I won't get there and they'll say, actually we need to take your car in order for you to get this meal. We benefit from the rule of law every day, walking down the street. Just it's a part of our everyday lives. And it's something that, I personally don't necessarily always express gratitude for, but I should, because it's a great gift that our country has. We receive so many benefits from the rule of law as individuals, but it also requires our own personal accountability. That's essential for the rule of law to be successful, is that we have our own individual fidelity to the rule of law. There's a Canadian psychologist, Jordan Peterson, and I quote, he says, "We all contribute to the outcomes of life. Once we understand the outcomes, it becomes our responsibility to nudge them towards more stable and beneficial situations." And when we individually have a fidelity to the rule of law in our country and we respect it, it helps benefit our society. We have personal accountability, more stability in our country, access to justice for everyone, regardless of sex, race. We certainly aren't a perfect country, but we are so much better than the great majority of countries. The rule of law leads us to respect for human rights. It preserves human dignity. It promotes economic success. We have less corruption in our society. We have less violence in our society because of the rule of law. There's a United States Circuit Court of Appeals judge for the Third Circuit, Judge Hardiman, who has said that we can't have peaceful interactions with each other without the rule of law. And it is so vital for sustaining peace. And it is a constraint on individual behavior, but it is for the greater preservation of freedoms for all. I think when you look at societies that did not value the rule of law, where individuals did not hold dear the rule of law, you can see how disastrous and what hardship has come to those societies during those periods of time, such as the French Revolution. After the storming of the Bastille in 1789, which is the same year that our country executed our United States Constitution, you can see what happened. You can see all of the desecration of art, monuments, vigilante acts. Just it was rioting in the streets, beheadings. It was so many years of the reign of terror. Very just a society that's not stable. So that I think that's a good example of what it looks like when people don't value the rule of law or are not enacting fidelity to the rule of law. And it's just kind of like a vortex of anarchy. And the result of the French Revolution was that the void for the rule of law was then filled by a dictator, Napoleon, who reinstituted the rule of law, but in a corrupt way. So we can see just how vital the United States Constitution is and how its protections of individuals and our individual freedom is so vitally important to the stability of our society, and to our success. And crucial to this, crucial to ensuring that there is the rule of law, is having the criminal law. And so there's a redress for harm done to individuals when a harm exists, when it threatens the structure of our society and threatens personal freedoms. So criminal laws and the preservation of criminal laws and the just execution of criminal laws are absolutely necessary to our existence of liberty as a society, because they protect they protect the individual, and they protect the individual by instituting penalties for criminal behavior, by deterring criminal behavior, by instituting just punishments for criminal behavior. And this ensures that individuals who don't follow the rule of law from time to time then are punished and encouraged to follow the rule of law. And it ensures less infringement on individual liberty of those who do want to follow the rule of law and who want to live in, you know, a safe and peaceful nation, and not be deprived of their life, liberty, property, happiness. So America is really an amazing country because we have such strong individual liberty. And coupled with that, to ensure and piggyback that individual liberty is a component of the rule of law. And so individual liberty is protected by the rule of law, and they're both dependent on each other. And even when a person violates the rule of law and commits a crime, we see that our Constitution protects that individual's freedom that's so important to our society. So that person is protected from illegal search and seizure. And if the government illegally seizes a piece of evidence, then that evidence may not be admissible in a trial against that individual. There's a presumption of innocence. I remember years ago, my mom was picked for jury duty, and the prosecutor, during the voir dire process of deciding who would be in the jury, asked her to prove how she got to court. And my mom is a pretty quick-witted lady, and she said, well, I don't have to prove how I got to court today. You have to prove how I got to court today, to the prosecutor. And she was very quickly kicked off the jury and did not serve on that jury. But there's this presumption of innocence where the prosecutor has to establish beyond a reasonable doubt in criminal cases that the person was guilty of the offense. And there's parts of the offense. It's not some vague law. It's clear, you know, did the person do X, Y, Z? If the prosecutor proves by, you know, beyond a reasonable doubt that the person did do X, Y, and Z, then they'll be found guilty by a jury or by a judge. And so we have this presumption of innocence and this burden on the state to prove the case. We have the protection against self-incrimination. A person does not need to incriminate themselves or speak, you know, to the police. There's a bar against double jeopardy. A person won't be tried twice for the same crime. They will be given a speedy trial. They'll have the right to call witnesses, to cross-examine witnesses. They can have counsel, no cruel or unusual punishment. So we have, you know, our system in place, and while again it's not perfect, it's replete with constitutional safeguards, and those safeguards are insulated by the rule of law. And for the individual, the rule of law, it really touches all aspects of our individual rights. It ensures the stability of our society, our safety, our ability to live out our beliefs, our individual freedoms. And an aspect of it does hinge on us as individuals in the society acting with fidelity for the rule of law. But our country has been so successful because of our Constitution and our system that protects the Constitution through the use of the rule of law, the exercise of the rule of law in our society.
That's beautiful. Thank you so much, Erin.
Oh, thank you.
It says a mouthful, and it definitely speaks to exactly some of the issues that we're really seeing unfolding across our nation right now, and specifically here in Michigan. I do want to check back in with Judge Michael Warren. Are there any more comments from our Facebook Live audience? I want to be able to give them an opportunity to be heard in case any questions did come in.
They are simply spellbound, and we have
Well, I have no doubt about that.
absolutely. Erin just knocked them. It just
All right. Well, thank you for that. The chat box has been quiet during this last period of time, so we don't have any further questions from our live audience. I would like to take a moment to go to each of you as our speakers and be able to give you opportunity for one last comment as we get ready to close. Prior to that, let me just hit on this again in the chat bar. If you have not already seen it, I do want to mention to you, Judge Michael Warren's organization, patriotweek.org, is listed. They are having events all week long during this as Patriot Week. Obviously, you know, yesterday was the anniversary of 9/11, and patriotweek.org is going to have a fabulous lineup all week long of different events that you can plug into. AmericasSurvivalGuide.com is where you can find his latest resource. RWFM.org is where you can join the Republican Women's Federation of Michigan. We would love to have you plug into one of our 20-some clubs across the state, and we're totally welcome to set up a new club if you are so inspired in your area. We also have saltlightglobal.org, which is Professor William Wagner's organization. All of these resources that these wonderful folks have are available to you, not only today during our live broadcast, but also on the recording at any time in the future. Please feel free to go there and access these. Let's start with the good professor, William Wagner. Do you have any last minute comments?
Well, I would add one more website to you, because our legal division at Salt Lake Global, Erin is our chief of Supreme Court practice, is the Great Lakes Justice Center. And so it's greatlakesjc.org, greatlakesjc.org. And so you can see how the rule of law is actually protected on a day-to-day basis. And that would be where I think I leave it. Each, generation is tasked with, stepping up and standing on the shoulders of those that came before us. Mm-hmm. And we walk away today with a much better understanding of the importance of the rule of law and how it, preserves our freedoms and how it allows us to function in society with good governance. And when we lose good governance, if we don't use the rule of law, and we have threats to our religion, to our liberties, if we don't have the rule of law. But I think I would leave with the point that each one of us, has a responsibility to step up and, preserve the rule of law during our time, because it doesn't naturally happen. It doesn't happen unless, we take an active interest and sometimes even more than an interest, actual action to preserve that rule of law. That's the difference between a lawful protest being protected and an unlawful riot where somebody destroys property or harms another individual. So God bless all of you, and thank you for inviting us. This was an absolute privilege to be part of this.
Thank you so much, Professor Wagner. And yes, I did add greatlakesjc.org to our list of websites. Thank you for that addition. And thank you for your time and dedication to all the principles that you uphold on your side of the coin. We appreciate your time today. Thank you so much.
Thank you.
Erin Mersino, may we get any closing comments from you, please, ma'am?
Oh, thank you. I truly just wanted to thank everyone here today. Thank you for tuning in. Just really appreciate your interest in the rule of law. When I look around and I see these individuals from these amazing organizations, such as the Republican Women's Federation of Michigan, from Patriot Week, from Salt Lake Global, the ability to represent the Great Lakes Justice Center and the tremendous work that they do there, I just have such hope for America and America's future. And so please stay engaged, stay involved. Buy Judge Warren's book, America's Survival Guide. It's extraordinary. Go to his website and immediately after this is done and get his book. It's wonderful. And just truly thank you. And thank you for your time and attention, and keep up with everything that, because if our liberties are not defended continuously, vigilantly, then we will be looking at a very different America one day. And so it's absolutely vital that you stay active, stay engaged, stay involved. So thank you so much.
Thank you. We are definitely seeing the battle for the soul of our nation playing out before us right now. And each and every one of us has an opportunity to step into position to let our voice be heard. Thank you for doing your part to empower us to be able to do that effectively.
Oh, thank you.
Judge Michael Warren, host of our day today, thank you so much for being here and for organizing this with us. Share with us, please, any closing comments that you have. Judge Warren, your mic is muted.
Sorry. First, I want to thank Erin for her very generous comments. It's very nice, as well as Professor Wagner and Robyn. Thank you for all that you've done in helping putting this together. It was a fabulous program, and the good thing is it's now preserved for forever, so that hopefully it will live on and be viewed by thousands and thousands of people. I want to quote Abraham Lincoln, and he addressed the Young Men's Lyceum of Springfield, Illinois in 1838. And he said, "At what point then is the danger to be expected? I answer, if it is ever to reach us, it must spring up amongst us. It cannot come from overbroad. If destruction be our lot, we must ourselves be its author and finisher. As a nation of free men, we must live through all time or die by suicide." Unfortunately, we have had a couple of generations of just terrible education in connection with our Constitution, civics, our founding first principles from a Declaration of Independence, which include the rule of law, among others, such as unalienable rights, limited government, the social compact, inequality, and the right to alter or abolish an oppressive government. And if we don't understand our founding first principles, and we don't understand why we are so blessed to live in a time and place such as this, then we are doomed to lose our freedoms and liberties. And the first step in that is to understand that there is a rule of law, why it's important, and how it affects what we should do and what the government should do, and to really embrace it and make it not just some kind of lesson that you walk away from after a few minutes, but that you live and breathe. And when there's challenges to the rule of law, to face those challenges. And I want to thank Professor Wagner and Erin for marching into courts and fighting for our liberties and freedoms. It's so vitally important. I see David Coleman's on the call too, and I know he does the same thing. If it wasn't for champions like that, we would be in a much worse situation than we are already. But it's going to be extremely important, not just for lawyers, but for everyone, to stay engaged, to renew the spirit of America, fight for our liberties. Because as Erin said, if we don't do it, we're going to lose it. And America is truly exceptional. There's only been a few, we're the only country like us ever in the course of human history. And history is replete with nations that, for one reason or another, collapse either from within or from without. And I think Lincoln is right. We're too strong to be defeated from without. But the hollowing out of our understanding of who we are as a people, and we see a lot of that today in the mass media and demonstrations and other forms of attack and critique of our foundations as Americans, and we have to fight back, or we're going to lose the country. So thank you for being here. Please keep up the good fight. God bless you, and God bless America.
Thank you so much, Judge Warren. Ladies and gentlemen, thank you so much for joining us today. RWFM has been a proud sponsor of today's Rule of Law event. This is just one avenue that we have chosen to use to advocate, communicate, educate, and motivate. Even though this is going to be available as a recording, because we're live now, I will say, if you are not already registered to vote, please go do so. That's one of the most basic things that you can do to have your impact and make your footprint and let your expression be seen and counted. So please, if you have not already registered to vote, please do so and make sure that those near you also are registered to vote. This has been an amazing time. Thank you so much for your attention today, for carving out time from your busy schedule. God bless you. God bless the USA, and make America great again. Thank you all.
Thank you.